Well, South African consumers have been receiving text messages from their banks and other service providers informing them of a VAT adjustment of 0.5% as of May the 1st, 2025, in accordance with VAT rate increase. Now, there's uncertainty about whether the VAT increase will actually come into effect, given that the DA has filed an urgent application to prevent the same thing from happening. Well, chartered accountant and independent analyst Khaya Sithole has written a piece about these processes, and he joins us now to discuss it. Good afternoon. Now, what is the correct approach with these service providers in terms of sending out these notices?
Good afternoon. Good afternoon to the viewers. So the reality here is that until there is something that emerges that says that the 15.5% VAT rate will not materialize on the 1st of May, it is actually the responsible thing to do for service providers to actually notify their customers that from what we've heard, from what we've seen, there is indeed a new VAT rate, and this is how it affects the way in which we transact with you. So it is what they have to do until there is an instruction that comes from the politician that says, well, actually, beyond the 1st of May, the VAT rate of 15% will still persist. But as far as it stands right now, 15.5% is the answer to every question that says what will the VAT rate be after the 1st of May in South Africa.
Now, you've written a piece on how finance ministers should be approaching tax adjustments and the question of setting and adjusting rates. What are your misgivings about this particular process?
Well, the problem here is that it seems that most politicians or parliamentarians are not aware of what they actually did in 2018. So what happened in 2018 is that National Treasury highlighted that actually when it comes to the variation or the changes in tax rates, there were different rules amongst the three main taxes, which would be income tax, dividends tax, and indeed the VAT Act. So what they did is that they said, look, let us simply make sure that the rules are consistent. So before then, what we had for a very long time is a rule that said in the VAT Act, if the minister makes an announcement that the new VAT rate is going to be a particular number, and then it announces a date, that rate actually becomes effective. And then Parliament has a 6-month window period in order to rectify or to reject it. What happened then is that this window has been extended to a 12-month period. Simply means that whatever the minister pronounced this year in relation to the new VAT rate, Parliament has got 12 months in order to undertake its own processes and then ultimately rectify that. In the interim, the rate actually applied. So the key question here is whether there should indeed be a rule that enables a finance minister to simply make this announcement and for it to be effective and for Parliament to have such a lengthy window period in which it then either concurs or rejects what the minister says. So that seems to be the point of contention here. What the DA has now done in its court papers is that it has indeed attacked the essence of that particular question by saying that as far as they're concerned, it is unconstitutional for any clause in the law to give so much unilateral power to a minister to set a binding rate, particularly given the fact that should it then turn out that Parliament rejects it, it is impossible to imagine how it can then be refunded back to the customers that will pay. So that is the crux of the problem that we're dealing with now.